Hi, Karen here. Today I'm really excited because today I'm going to be breaking down clips of American movies and legal dramas all about criminal law. I've been a full-time criminal prosecutor and criminal defense counsel for over 20 years now. As you may know, I am actually a qualified lawyer from Ontario, Canada, and I'm also a qualified barrister here in England and Wales. I did pass the New York bar, but I do not consider myself an authority on American law at all. Let's roll the first clip. The good wife approaching the bench.
I've never tampered with evidence.
So, if I asked you about this internal affairs report...
Objection, Your Honor.
Mr. Gardner, really, up here.
A couple of things here. First of all, in Canada and the UK, we don't have that whole concept of approaching the bench. That's definitely an American thing. Anything that is said in a courtroom goes on the record. The other aspect is that Will, the defense counsel, is trying to use the criminal record as something negative against the police officer to show that he's a bit of a dodgy character and might tamper with evidence. But we'll see that the actual infraction was extremely minor.
And it was minor. Drinking beer on duty?
You are playing with fire here, Mr. Gardner.
Your Honor, any internal affairs charge is completely relevant.
No, sir, you're trying to imply to the jury that something more nefarious is going on here, that Detective Burton planted evidence. Let's at least be adults here and admit to each other what you're doing.
Your Honor, no. Oh my God, no.
Look, I will admonish the jury. That's all I can do, Mr. Brody.
If this ever happened in Canada or the UK in front of a jury, I can tell you that Will would be disciplined for doing that, because quite obviously that's exactly what he's trying to do. And the second thing is that would be grounds for mistrial. They would be able to stop that whole trial and they'd have to start again with a brand new jury. So this is actually quite serious what Will is doing here.
Brody, and you watch it, Mr. Gardner.
Liar, liar, continuance.
How are we doing this morning, Counsel?
Your Honor, I would like a continuance.
Case has already been delayed.
I realize that, Your Honor, but I would really like a continuance.
I love this movie. It's one of my favorites. In the UK and in Canada, we don't have continuances. That's an American term. What we have are adjournments, and you can apply for an adjournment, and that's what he's trying to do.
I have to hear good cause, Counsel.
Can't lie!
Why do I like this movie so much? It makes lawyers look bad. But if you are in a situation, even when a trial date has been set and you need an adjournment, you need to tell the court why you're going to have an adjournment. You can't just show up and say, I want to have this delayed. The judge is quite right, actually, to ask for reasons why. That is exactly what would happen in Canada and in the UK.
A continuance denied.
The inability to lie, sadly, is not grounds for an adjournment. How to get away with murder. Objections.
Explain why your eviction suit against Miss Morelli was dropped despite her inability to pay rent.
Cheating?
Is it because her lost rent money was nothing compared to the millions you made once Miss Stanley was out of your way? Answer the question, Senator.
If a judge is telling a counsel to stop talking, that it's enough, then the lawyer should know that they have to stop talking immediately. You cannot ignore what a judge has told you. That is grounds for discipline and actually grounds for contempt of court.
You do not have the time to answer for who bore the real cost of your development.
Objection!
If the lawyer for the opposite side objects, then that lawyer must stop talking immediately. And if they don't stop talking immediately, then again, that is a grounds for disciplinary action.
The thousands who were displaced in the name of lining your pocket.
Again, it sounds like the judge is trying to interfere and she's just not having any of it.
That is enough.
Please, Your Honor.
Again, the judge is the ruler in the courtroom and lawyers would well know that, even if the judge is a bit of a... Gavels. This is so American. We don't use gavels in the UK, and we don't use them in Canada either. Madea goes to jail. Miranda rights.
Your Honor, our officers forgot to Mirandize her.
I was waiting for Miranda to come in and nobody came in there. I was waiting for her. That's right, ain't nobody Miranda me. Miranda wasn't even in the room.
Probably one of the most famous aspects of American justice, the Miranda rights. Miranda rights are the rights to silence that are said by police officers when they arrest somebody. You have the right to remain silent.
Right to remain silent. Anything you do or say can be used. What's the next part?
As a flotation
as a flotation device.
The rights that are given to arrested people in Canada are very similar to the Miranda rights in the States. They do have a right to remain silent. In the UK, you have a qualified right to silence. You choose to remain silent, that silence could be used against you. So actually, the Miranda warning in the States is more similar to the Canadian experience than it is to the UK experience.
You gotta let me go.
My Cousin Vinny.
We got somebody for you.
You must be Stan. How you doing?
Why'd they bring you in here?
Well, I just got in. I asked where the new guys were, and they brought me right in. Hey, sleeping, huh? Cute little guy.
When a lawyer goes to visit clients in jail or in the holding area, they don't go in the cell. You go to visit a client in jail, they have specific rooms. They'll have professional visiting rooms, which are different from family visiting rooms or friend visiting rooms. You may know that when sometimes people go to visit prisoners, there's a phone that you pick up on either side of a glass. You'll often get the phone call type of arrangement and the glass between you if you're in the bottom of a courthouse or in the bottom of a police station. That's very, very common. You will go into the room with your client, but it's a very safe place because there's always going to be a glass window in the door or a plexiglass window in the door. But there's also going to be a very important panic button, and you will seat yourself right by the panic button just in case something happens. 99.9% of the time your client will not be handcuffed or shackled unless you ask them to be. I've never asked that. I've never had a client handcuffed or shackled when I've gone to visit them, and I have never felt in danger at any point whatsoever. There's been a couple of times where they have been shackled when they've come to me because usually they got in a fight with somebody and now they're in solitary, and if that happens they will come to the room in shackles, but I ask them to get them taken off, and that's absolutely fine. But this just would not happen in Canada or the UK. You just don't see your client in a cell.
You know, maybe I just start with you. Let him sleep a little bit.
I don't want to do this.
Hey, I don't blame you. If I was in your situation, I'd want to get through this whole thing as quickly and with as little pain as possible. So, let's try our best to make it a simple in-and-out procedure.
A few good men.
Luce, Your Honor, you had markers inside a bony transport. Your Honor, you doctored the log.
This is actually a court-martial, not a criminal trial, so there are different rules. I have been involved in a court-martial in Canadian soil. I haven't been involved in one here in the UK. I have represented soldiers in civilian courts. These are usually soldiers that will be automatically kicked out of the military as soon as things are over, and they want them to serve a civilian sentence. It's usually lower-ranking officers as well.
Contempt. Colonel Jessup! Did you order the code red?
You don't have to answer that question.
I'll answer the question. You want answers?
I think I'm entitled.
You want answers?
I want the truth!
You can't handle the truth!
The Untouchables.
Bailiff, I want you to switch the juries.
Yes, sir. Your Honor, I object.
In Canada and the UK, there is no way that a jury would be switched. That just does not exist. Again, I don't know what the rules are in the States. I do know that in the Al Capone trial, which is what the Untouchables is about, the jury was switched. There had been jury tampering, and they did do that in real life. Obviously, it certainly used to be something that could be done in the States, but it's not done here. If there is any evidence of jury tampering, they'll just get rid of that jury and they'll just pick a new one.
Do something. Do something. Order! Your Honor, we would like to withdraw our plea of not guilty and enter a plea of guilty.
And that would never happen either. Again, I don't know about American law, but a lawyer in UK or Canada cannot enter into a plea or change a plea without his client's consent. I'm anticipating this might be a bit of dramatic license, I'm not sure. What I can say is that in the real trial of Al Capone, he didn't change his plea. He kept the not guilty plea. He went to trial, and he was convicted with this new switched jury, and he got 11 years, and these charges dealt with tax evasion. He served 7.5 years of his 11-year sentence, and then he was released, and then he died of a stroke 7 years after being released. The Simpsons, court attire.
And so, ladies and gentlemen of the jury, I rest my case.
Mr. Hutt, do you know you're not wearing any pants?
What?
American lawyers only wear suits to court, no matter what level court they're in. In Ontario, and I think this applies all over Canada, but in Ontario, if you're in the lower court, what we call the provincial court, you're still before a judge, but you just wear suits and normal clothes. If you're in the higher court, what we call superior court in Ontario, or court of appeal, or anything above the provincial court level, then you would be gowned, and you'd wear your gown, you have a jacket, and you have tabs, no wigs. Now in the UK, you, again, in the very lower courts, what we call magistrates court, you don't gown up for that, but in any of the higher courts, solicitors will wear a gown and tabs, and it's pretty well the same gown. I can wear my Canadian gown over here, and the barristers, if they're gowned up, they also wear the wig, which is ridiculous. I mean, obviously, if it looked good on me, I'd be all for it, but no, it's ridiculous. Nobody looks good in those wigs. Nobody. And justice for all.
Prosecution is not gonna get that man today. No. Because I'm gonna get him. My client, the Honorable Henry T. Fleming, should go right to f***ing jail!
One of my favorite movies again. That would never happen in Canada or the UK. You never would have a defense counsel throw in the towel and throw their client under the bus. Again, I don't know what the rules are in the States, so I can't comment on that. But I do know that in Canada and the UK, the legal privilege between client and counsel is sacrosanct. And that means it can't be revealed. So even if your client tells you that they're guilty of something, you cannot use that or reveal that to be used as evidence against that person. But certainly that could never happen in the UK or Canada. If it did happen, he would immediately lose his license to practice law.
The man is a slime. He is a slime. If he's allowed to go free, then something really wrong is going on. Mr. Kirkland, you are out of order. You're out of order. You're out of order. The whole trial is out of order. They're out of order. That man, that crazy, depraved man, raped and beat that woman there, and he'd like to do it again. He told me so. It's just a show. It's a show. Let's make a deal. Let's make a deal. Hey, Frank, you want to make a deal? I got an insane judge.
Objection?
Order.
I just think there's nothing better than watching a real-life crime drama or a movie about the law. Nothing like it. Bye for now.
Your father's passing.